So, this video comes to you as a result of the feedback I received from the people who watched my detaining Antifa stream. I was thanked for teaching people how to arrest Antifa, which, although I appreciate the thanks, wasn't an entirely accurate representation of what that stream was about. That stream was intended to cover a couple of issues, one of which being the laws surrounding the employment of citizens' arrest tactics against violent rioters, but which also included what types of personal protective equipment an attendee of such volatile demonstrations should consider donning, and the type of hazards that may be encountered and how to respond to them. This video will be much more to that point, so let's get to it. Conducting a citizen's arrest is not something that you should take lightly, as it is an act that can leave you facing both criminal and civil charges if not handled responsibly. Viper's first rule of arresting Antifa? If you're not sure, don't fucking do it. I would hate to see well-meaning people getting locked up or sued while trying to do some good in the absence of an engaged police force, especially if I was in any way an inspiration for the actions that left them in that particular bind. So, everyone, follow Viper's first arresting Antifa rule, and if you're not sure whether or not to conduct a citizen's arrest, don't. Before we go any further, I feel it would be appropriate to look at the pertinent laws regarding citizen's arrests and in which circumstances you are able to conduct such an action. While I understand that I am repeating myself, I must make it absolutely clear that to conduct a citizen's arrest places you in a position of serious personal risk both to your physical person during the arrest and to your reputation, record, and finances in the event of a civil or criminal case being brought against you for something like false imprisonment. Having made that, I think, abundantly clear, let's take a look at the citizen's arrest legislation in a state with quite frequent Antifa interference, California. Let's start with the California Penal Code, Chapter 5, Arrest by Whom and How Made, Section 837. Quote, a private person may arrest another, 1. For a public offense committed or attempted in his presence, 2. When the person arrested has committed a felony although not in his presence, and 3. When a felony has been in fact committed, and he has reasonable cause for believing the person arrested to have committed it. Now, it should be obvious, but the use of he does not in any way establish that it is only male citizens that may enact a citizen's arrest. The law was enacted in 1872, and its wording is simply a sign of its age. Actually, that's rather odd, a solid litmus test. If you're the type of person to get worked up over the use of his in this piece of legislation, then you're probably not equipped to handle the serious nature of a citizen's arrest in the first place. Now, breaking it down, California's citizen arrest law sets out protections for an individual conducting a citizen's arrest under the following circumstances. Firstly, when the individual enacting the arrest has just witnessed the commission of a crime under the California Penal Code and is enacting the arrest based on the offending individual. This one's simple. If you see someone commit a crime under the California Penal Code, you have the right, as a citizen, to enact a citizen's arrest. Number 2. When an individual has committed a felony offense, however said offense was not observed in its commission by the individual enacting the arrest. This one could be a bit confusing, but it's basically saying, if you know for sure that someone has committed a felony, you have the right to arrest them for said felony. And number 3. When an individual has reason to believe that the subject of their citizen's arrest committed a felony offense. This subsection differs from the former as it represents a situation where, while a felony has in fact been committed, the individual making the arrest cannot be absolutely positive of their suspect's guilt, but they may also make a citizen's arrest should they have a reasonable cause for their belief in the suspect's guilt. Simple enough? Wonderful. Now let's move on to the topic of the use of physical force and other details, the understanding of which may come in handy should you ever find yourself needing to rely on citizen's arrest laws in the state of California. Let me first direct you to California Penal Code, Chapter 5, Section 8, 839. This section deals with requesting assistance in the arrest of another citizen, and as most of these engagements with Antifa rioters occur in groups, you should probably understand this particular part. Section 839 reads as follows, quote, "Any person making an arrest may orally summon as many persons as he deems necessary to aid him therein." End quote. Okay, I might have made this section seem a little bigger of a deal than it really was. Either way, now you know that if you deem necessary, you can call for people nearby to assist you in conducting a citizen's arrest, provided your arrest meets the necessary legal criteria, if you might otherwise struggle to restrain or detain the subject of your arrest. Now, Chapter 5, Section 840 of the California Penal Code describes at what time of day an individual may legally enact a citizen's arrest, but it exempts arrests made in a public space from any such time constraints, and the vast majority of these demonstrations and gatherings seem to be taking place in public spaces, so I'm confident in passing it by. However, if you're concerned about where and when you can make a citizen's arrest when not in a public place, you're looking for California Penal Code Chapter 5, Section 840. Get reading. Next up, we'll be looking at Section 841 as it pertains to the responsibilities of the individual making the arrest to make clear the purpose for and nature of the arrest to the subject party. California Penal Code Chapter 5, Section 841 states, quote, "The person making the arrest must inform the person to be arrested of the intention to arrest him, of the cause of the arrest, and the authority to make it, except when the person making the arrest has reasonable cause to believe that the person to be arrested is actually engaged in the commission of or attempt to commit an offense, or the person to be arrested is pursued immediately after its commission or after an escape. The person making the arrest must, on request of the person he is arresting, inform the latter of the offense for which he is being arrested." To break that down, if you are conducting a citizen's arrest, you must inform the subject of said arrest of the following facts. 1. The fact that you intend to arrest them. 2. The reason that you are conducting that arrest. And 3. The fact that you, as a citizen, have the authority under California Penal Code, Chapter 5, Section 837, to arrest them for their offense or offenses. There are, of course, circumstances under which you are allowed to delay in making such statements. You are not required to forewarn the subject of your citizen's arrest in the state of California if, 1. They are, at the time of your arrest, committing or attempting to commit the crime for which you are arresting them, and 2. The person you are attempting to arrest is fleeing the scene of the offense or has escaped from being detained for said offense. Simplified, if they're in the process of committing the crime or they're fleeing the scene of the crime, or their subsequent detention for said crime, you may make a citizen's arrest before formally notifying the party to be arrested of your intent to arrest them. Okay, that wasn't really simplified, was it? Basically, if they're running or escaping detention, arrest them first and give them the reason for their arrest after. That better? I hope so, because it's going to have to suffice. Now let's skip ahead somewhat to Section 846. The intermittent sections would not, as far as I can tell, apply to a situation like a Battle of Berkeley incident, and as such are not important in the scope of this video. California Penal Code, Chapter 5, Section 846 establishes your right to disarm the subject of your arrest and reads as follows. Quote, "Any person making an arrest may take from the person arrested all offensive weapons which he may have about his person, and must deliver them to the magistrate before whom he is taken." In the event that you were wondering, a magistrate is covered in Chapter 3, Section 808 of the California Penal Code, which reads, "The following persons are magistrates: A. The judges of the Supreme Court, B. The judges of the Court of Appeal, C. The judges of the Superior Courts." I understand that it may seem to be indicating the proper course of action to be to present any offensive weapons as confiscated from the arrested party only to a magistrate. However, I would caution everyone against such literalism. If you have thoroughly documented the confiscation of the items, and noted from whom they were taken, I would encourage any and all individuals making a citizen's arrest to turn over said items to an officer that requests them. I would even go so far as to recommend offering to turn over the arrested individual's confiscated weaponry, again so long as you have properly documented their confiscation. In short, and I suppose this counts as Viper's arresting Antifa rule number 2, cooperate with law enforcement. Folks, the arrest isn't going to be worth much if you get yourself arrested in the process. If a police officer requests any confiscated weapons or items, and you have any reservations about turning them over, just shut up, give them the confiscated items, and if you feel absolutely necessary, notify the officer in a respectful manner that you are concerned that this action has not been in accordance with California Penal Code Chapter 5, Section 846, and then shut the hell up about it. And now, for the final section of the California Penal Code to be examined in this video, Section 847, Subsection A. California Penal Code, Chapter 5, Section 847, Subsection A, has to do with your responsibilities after having conducted a citizen's arrest, and it states the following, quote, Subsection A, a private person who has arrested another for the commission of a public offense must, without unnecessary delay, take the person arrested before a magistrate or deliver him or her to a peace officer. End quote. Essentially, if you are going to detain and arrest someone, you must, as soon as it could be deemed reasonably possible, take them before an individual defined as a magistrate by the California Penal Code or to a police officer. I understand that it may seem reasonable to detain arrested individuals in groups, given the nature of these riotous demonstrations. Keeping them in one spot might be simple. However, you risk charges of false imprisonment for doing so under California Penal Code Chapter 8, Section 236, the punishments for which are outlined in Section 237 of the same chapter, which are laid out as follows. A. False imprisonment is punishable by a fine not exceeding $1,000 or by imprisonment in the county jail for not more than 1 year, or by both that fine and imprisonment. If the false imprisonment be effected by violence, menace, fraud, or deceit, it shall be punishable pursuant to Subdivision H of Section 1170. End quote. Considering that some degree of physical violence will most likely be involved in the detention of a rowdy Antifa rioter, you can be damned sure that any charge of false imprisonment will have that modifier tacked onto it. Even if violence is not a part of the arrest or imprisonment, the arrested party could almost definitely claim that being isolated and restrained in the midst of an antithetical mob would constitute menace. Just in case you were curious as to what modifiers come into play should you be convicted of false imprisonment with the added aspects of violence, menace, fraud, or deceit, Subdivision H of Section 1170 outlines multiple expansions upon the baseline sentencing for false imprisonment, the most noticeable of which is that, instead of serving your term in a county jail, you'll sit it out in a state prison, which I hear makes county jail seem quite nice. Bearing that little detail in mind, you might want to remind yourself of Viper's first rule of arresting Antifa. If you're not entirely sure that your conduct is lawful and reasonable, don't fucking arrest anyone. Are we good? Good. Good? Good. Great. Call them what you like, so long as you don't cross the line of impersonating a police officer, you might want to adapt a role demonstrated in the following video to suit the purpose of conducting organized, effective, and most importantly, legal citizen arrests. That role? The street medic.
Fuck the Eagles! What are you gonna do, bitch? What are you gonna do? Hey, back the fuck up, bro. I'll treat you like a man. Personal property. That's what you want, right? Eagle rights? You go.
I'm filming you.
Oh, I'm gonna hurt you. I'm gonna hurt
Because you have a mask on. Oh, shit.
Hey. Oh! Motherfucker. Oh, shit, he's bleeding. Yo. Hey, man. He's bleeding. Hard.
You see the guy in the bright shirt with the red duct tape crosses and the douchebaggy Guy Fawkes mask? Really, dude? V for Vendetta is like so 11 years ago. Anyway, this guy here is what you'll see defined on Wikipedia and activist sites like paperrevolution.com as a street medic. Street medics, sometimes known as action medics, are defined as volunteers with varying degrees of medical training who attend protests and demonstrations to provide medical care such as first aid. Unlike regular emergency medical technicians who serve with more established institutions, street medics usually operate in a less formal manner. End quote, and of course, if you couldn't tell by the Guy Fawkes mask and the duct tape crosses. Essentially, you have someone with a particular skill set or knowledge base who fills an essential role within the demonstration. In the case of a street medic, that means administering first aid to injured persons while waiting for emergency medical technicians, and, in some cases, assisting EMTs as requested with various tasks. It would be my advice to any protest group or organized gathering of demonstrators to pre-select an individual or individuals with sufficient knowledge of citizen arrest laws to be the ones handling such matters in the field. And my reasons behind this are simple. First, it allows for a small group of people to focus almost exclusively on citizen arrest procedures, giving the best chance that such actions will be conducted responsibly and without breaking the law. Second, it allows for the necessary assets for conducting a citizen's arrest: zip-tie cuffs, evidence bags, Sharpies for labeling evidence bags, so on and so forth, to be concentrated with the individuals most likely to use them. And third, and finally, it gives the police a distinct individual or group of individuals to speak with in regards to any citizen's arrests that are made, which streamlines the entire process. Now, you don't have to listen to my opinions on this issue. You're free to do whatever you please, whether that means establishing a citizen's arrest corps or not. However, if you don't decide to establish such a role within your protest, and it comes back to bite you in the ass, well, I'll have told you so. And that, folks, brings us to the end of this video. If you've skipped ahead to the end in anticipation of this wrap-up, good for you, here goes. JT Viper's arresting Antifa rules. 1. If you're not sure if a citizen's arrest is justified, or how to conduct one, don't attempt to conduct one. Second, number 2, comply with law enforcement efforts. 3, know your state's laws regarding citizen arrest and know them backwards and forwards. Number 4, if you want the best chances of your citizen's arrest turning out real results, consider establishing a dedicated individual or group of individuals to conduct such arrests, detain those arrested, and interact with law enforcement based around those arrests. Number 5, none of the things I've said here constitute legal counsel in any way, shape, and or form. They are my opinions on my analysis of the legal texts available to me and should not in any circumstances be treated as legal counsel. And number 6, and most importantly of all, stay safe out there, folks. Have a good one.